Thank you for joining me this Deaf Awareness Month. So, I said deaf. DEAF. Damn, this thing sucks. Okay. So today what we're going to be talking about, well, mostly we're just going to be reading from and kind of doing a reaction and commentary to an article called Breaking the Sound Barriers: How the Americans with Disabilities Act and Technology have enabled deaf lawyers to succeed. I said deaf. DEAF. If it says death, just assume I said death. DEAF. No, I said DEAF. Fuck. Okay. I said fuck, not back. Damn. Alright. Fuck, I hate that thing. So, before we get there though, we'll just talk a little bit about John F. Stanton, and we're going to check out a SCOTUS blog article he's mentioned in, and then we will also just check out the concept of breaking the sound barrier also, and reflect on that, and as it relates to the article and the series that I am doing, and and then we're gonna conclude after that. And the main reason I'm doing this is because the first live stream I ever did was a live reading of Alexander Graham Bell's memoir. And that thing was ableist as shit. No, I said that thing was ableist as shit. What the fuck? The captioner, I hate that thing. So that was a rough read. So I thought that for Deaf Awareness Month, it was really important to focus on an article and reading something that shows deaf representation, that shows, what helps us with access, accommodation, and our culture thriving, as well as different support needs, and discussing some of the key players in modern accessibility, particularly as it relates to how we were legally able to get to where we were, from the perspective of a lawyer. You know what I'm saying? Well, through his words, but then also through my perspective, because I'm going to be adding my own commentary reaction to it. And if you want to read it without that, it's linked in the description of this video. Or you could just Google it if that link ever stops working. But yeah, if I ever notice it stops working, I'll try to replace it if I can do that. But yeah, alright, so I'm gonna roll my intro, and then we'll just get started. Hi, my name is Lexi, aka Deaf Child. I'm born deaf, hard of hearing. My team was one of the top teams between 2020 and 2024 in New Orleans and Louisiana. I began doing business as Deaf Child in 2013, marketing 2011, and sales 2009. I've earned 50 plus certifications in marketing and sales, and I have my Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Visit my site at noladeafchild.com. Hi, so first I want to check out a little article we have from SCOTUS blog. It's written by Mark Walsh, but even though it's all the way from 2016, I still think it's worth checking out today just for the historical relevance of it. But it's called A View from the Court: Making Accommodations for the Deaf and Hard of Hearing. And in here, it talks about members of the Deaf and Hard of Hearing Association being sworn into the Supreme Court bar. And particularly using electronic devices in this case. But it also talks about how John F. Stanton, a deaf appellate lawyer with the U.S. Department of Justice, introduced the 12 deaf or hard of hearing. Um, in deaf community, hard of hearing is deaf. There's no or. Like hard, like it's kind of like this. A rectangle can be a square, but a square is not a rectangle. You know what I'm saying? So, fucking, I don't know what the fuck that wink was. I feel stupid as shit. You know what? That was ableist. I'm working on my language. Um, Anyway, so he vouched for them for their entry into the Supreme Court bar. Um, and he is the author of a 2011 article that got published in the, I don't know how the fuck to say this word, dude. I honestly should have looked that up. Is it shit? No clue. But in a university law review, which we're about to read. And the law review article um, details some of the Supreme Court's past interaction with deaf lawyers. Um, and so, yeah, that's what we're going to check out. Um, and I'm excited to read it and read it together. And if you want to read this blog about this situation, it's linked in the description of the video. So I also want to talk two shakes of a lamb's tail about the concept of breaking the sound barrier. So it means traveling faster than the speed of sound. Um, and so uh, basically, when it's when an object breaks a sound barrier, it's said to be supersonic. And this search engine result page linked in the description of the video. And it's often measured in terms of Mach numbers. Mach 3 means the object is traveling at 3 times the speed of sound, for example. Um, and it was first broken by U.S. Air Force Captain Charles E. Chuck Yeager. Is that Yeager or Yeager? My bad. Broke the sound barrier on October 14th, 1947, flying a Bell XS-1 over Rogers Dry Lake at Edwards Air Force Base. And so typically, and civilian supersonic flights are banned to prevent sonic booms from startling the public or causing property damage. So, yeah. So when you think about that in relation to the air and flight, that is how we ended up with this live stream series having the photo of the sky in regards to where breaking the sound barrier occurs. So that's also where the cover image of this Deaf Awareness Month comes from. And which is in relation to John F. Stanton's article, Breaking the Sound Barrier, which I love that he named his article that, in relation to deaf advocacy. Like, I just thought that was incredible. So, yeah. Fucking, next up, what we're about to do is begin our reading. So I'm mostly going to be reading the damn thing, but obviously I talk too much, so I'll be adding my own commentary as well. Now, in the previous readings that I've done, which were from Alexander Graham Bell, those were more angry readings for me because I could be pretty angry when I'm reading that bullshit from him. But in this situation, I'm expecting a much different mood. I still do curse a lot, and I will expect that still. But I will be perhaps aggressive and passionate at some points. I can expect that, but it won't be an angry read. I'm not expecting that. Well, maybe there will be angry points in relation to discussion, the deaf oppression that we have to get through. But overall, because this is focused on the history, but also how deaf lawyers succeed, I think that I will be, in a better, like, just, mood and things like that. So, all right. So now I'm going to start reading the thing. So, at the beginning here, it does say, I'm gonna zoom this in a little bit actually, because to be honest, my vision sucks ass. And that way, perhaps it will show up better for you guys too. Okie dokie. So, and I'm also not going to read the whole thing this live stream. We're going to break this baby up into two parts. And so we're going to be doing part one right now, and then we'll do part two later. So, this is Reproduce with Permission, and you can cite as John Stanton, Breaking the Sound Barriers, How the Americans with Disability Act and Technology Have Enabled Deaf Lawyers to Succeed. Okie dokie. So, I'm not going to read all of the footnotes for this. I highly recommend, though, that you do go check out the footnotes and skim and scan those. But, so one thing I will note, though, like the one footnote I think I should read real quick. He says, for historical accuracy purposes, he has used some outdated terms because that was the way he found them in the cited materials. And many of these may be considered offensive today. So I think, that's important to note. And so, yeah. But I'm not going to focus on the footnotes because then we'd be here even longer. But I highly recommend you go on your own time, or, if I read too much and talk too much, if you want to space out while I'm rambling, read the footnotes as well. So, it says, in less enlightened times, Samuel Johnson once likened a woman's preaching at a Quaker meeting to a dog walking on its hind legs. It is not done well, but you are surprised to find it done at all. For much of America's history, many have made the same assessment of a deaf lawyer. Deaf lawyer Janine Kramer Madera came close to summarizing the sentiment when she once remarked of her practice, some court hearings and deposition that I'm particularly proud of, I got it right and did well, but didn't do anything that millions of hearing lawyers haven't done before me. When the Americans with Disabilities Act, ADA, was passed in 1990, the idea of a deaf person being a lawyer still seemed far-fetched to most of America. Although the number of deaf lawyers depends on the definition of deaf, hard of hearing, late deaf, and the definition of lawyer, active practitioner, member of a bar at some point. In the course of researching this article, I could only find 2, 3 at the most, instances of deaf lawyers with active practices between the 1930s and 1970. By 1990, my best estimate is around 20 deaf lawyers existed. And deaf identity is very complex. I did a whole 7-hour live stream on it. And I also have tried to summarize that. I forget. I think I did a summary of deaf identity in a 1-minute video as well. So you can either watch my 1-minute summary or my 7-hour summary. But me trying to summarize that now again in just a few minutes if I can is deaf identity can be complex. In deaf community, as it connects to deaf culture, deaf people perceive all spectrum of deaf, right? However, because of hearing assimilation and discrimination against us and internalized oppression that can come within that, because most of deaf people are assimilated into the hearing world, a lot of deaf people don't have a strong deaf identity. And so, they'll identify as hard of hearing, even though deaf people, we say they're deaf. Why are you hard of hearing? You have deafness. You're deaf. I'm hard of hearing and I'm deaf. Yeah, it's a hoedown over here. You know what I'm saying? So, and then late deaf people, I feel like, I don't know if it's appropriate, but in my head, I feel like a late deaf person is kind of similar to a reconnecting indigenous native person in my head, kind of very similar in terms of connecting to culture, in terms of, you know what I'm saying, becoming to terms with an identity and connecting to culture and building community, learning language. There's a lot of similarities, but I don't know if that's appropriate for me to make. um, Learning history, learning about your rights, a lot of things. But yeah, so everybody, the reasons a lot of people don't think they're deaf enough comes from hearing oppression against us. If you're deaf at all, you're deaf enough. You're deaf. Okay, let's cut the bullshit. In my opinion, my opinion. But anyway, let's keep reading. It says, having been involved in the deaf lawyer community for quite some time, reading dozens of articles on deaf lawyers, and corresponding with numerous deaf lawyers and law students, my best estimate is that there are currently about 200 persons who self-identify as deaf and who have obtained bar membership. If current law students or recent graduates seeking licensure are included, the number is 215 or 220. To put the number in some perspective, the American Bar Association had over 380,000 members in 2010. Oh, and I'm going to try to remember to link in the description of the video the summaries, the videos on deaf identity, the 1 minute summary and the big ass 7 hour one, if you'd like. The 1 minute summary is on my deaf history lesson, and the 7 hour one is a big ass. Actually, I think I might have done three. I think the 1 hour one is deaf identity relation to disability. I think the you know what? I have to go look for it. Okay, never mind. Sorry, but okay, let's keep going. This article discusses. Wait, am I reading the right? Yes. Okay, sorry. This article discusses how the ADA and technology have enabled deaf lawyers to succeed. Today we are, among other things, large firm litigators, prosecutors, public interest advocates, transactional tax lawyers, solo practitioners, government lawyers, public defenders, small firm general practitioners, in-house counsel, professors, and judges. I will first provide a background on the necessity of proper accommodations for a deaf person to succeed in the legal profession. I will next give a pre-ADA history of deaf lawyers and discuss some of the barriers that they faced. I will then move on to how the ADA and technology has impacted the lives of deaf law students and lawyers, and discuss what more can be done to ensure that the progress continues throughout the 21st century. And that's why I think this is so important to read. This focus on continuing the progress and understanding why weren't we successful before to what makes us successful now, I think is crucial for anyone, considering ways of deaf advocacy to understand how to better promote deaf autonomy. So yeah, first, necessity for proper accommodations for deaf lawyers. Prior to the ADA, even the Supreme Court's most progressive members impliedly agreed that intelligence or physical disability status bears a relation to a relation to ability to perform or contribute to society. On July 26, 1990, President George H. W. Bush signed the ADA, which had already been approved by an overwhelming majority of Congress, into law. Senator Tom Harkin, one of the ADA's sponsors, termed the ADA the Emancipation Proclamation for People with Disabilities in America. Yikes. I don't know if that's appropriate. That doesn't feel good. That's not right. Oops. I didn't process that before. That's fucked up, man. That's fucked up. I think that's fucked up. I think that's fucked up. Oh. Alright. Then it says, in the ADA's findings and purpose section, Congress stated inter alia, no fucking clue what that means. Historically, society has tended to isolate and segregate individuals with disabilities, and despite some improvements, such form of discrimination against individuals with disabilities continue to be a serious and pervasive social problem. Individuals with disabilities are a discrete and insular minority who have been faced with restrictions and limitations, subjected to a history of purposeful, unequal treatment, and relegated to a position of political powerlessness in our society, based on characteristics that are beyond the control of such individuals and resulting from stereotypic assumptions not truly indicative of the individual ability of such individuals to participate in and contribute to society. I believe that whoever the fuck is perpetuating this type of vernacular against anyone is a fucking piece of shit. You know what I'm saying? Anyway, so it says the chief benefit I'm not saying that someone's wrong for talking about the history of it. I'm just saying, I think you know what I mean, right? About like the concept. Okay. So, all right, then it says the chief benefit that the ADA has provided to deaf lawyers is the right to interpreting. With qualified interpreters, oh, you know what? I'm going to also try and remember to link my ADA playlist or my Aixon versus Lawfer playlist also in the description. And in that, and in my deaf law playlist, I think I put like the loopholes, why there had to be an update between the 1990 and the 2008 American with Disabilities Act. I wonder if they cover that here. Okay, so it says, with qualified interpreters, deaf persons generally have equal access to education as their hearing peers. As deaf lawyer Alexis no, I'm sorry, I don't know how to say her name. As deaf lawyer Alexis Kashar remarked when she was provided an interpreter in class, my whole world opened up with that interpreter. Communication existed in a way I never knew existed. I could actually find why students were laughing, participate in debates, answer questions in class. It was unbelievable. Undoubtedly, there have been numerous examples of lawyers who retired from the profession or had to find new specialties due to declining hearing. As late as the mid-1980s, Richard Ricks and Theodore Bertzos, both of whom became deaf in their 30s due to Meniere's disease, gave up their respective trial practices when they each concluded that no accommodations could allow them to effectively continue as advocates. I feel like people, who are late deaf have a different deaf journey, and they typically have trauma associated with that, and that typically, that typically takes more time for adjustment, in my opinion, versus people born deaf or become deaf in their childhood. We have like this window of time to adapt to functioning as deaf sometimes. You know what I'm saying? I don't know if that makes sense. But then it says, happily, both Mr. Bertzos and Mr. Ricks were able to resume their trial practices a few years later due to a combination of advanced legal protections, namely the ADA, as well as sufficient technology. Likewise, there are stories of attorneys who are less effective, to put it charitably, at their jobs because they did not have proper accommodations. The following is a somewhat humorous example of how a lack of proper accommodations can impede the deaf attorney's effectiveness. Probably the classic case that lawyers love to tell has to do with an old, very deaf attorney in Montpelier named John Center, who had a considerable practice in the Supreme Court, but was not very diligent in tending to it. He had this particular case on the docket that had been continued by agreement of the parties for several terms, never being reached for agreement. Eventually another term came around. Chief Justice Powers presided over the court and called upon Mr. Center to explain about that case. Mr. Center simply rose and said, "We have continued it by stipulation, Your Honor." Whereupon the Chief Justice, very angry at the many delays that had occurred, said, "Mr. Center, you cannot continue to make a fool out of this court." Mr. Center, of course, not having heard the remark at all, simply answered, "Your Honor, I thought we could by stipulation." But even if the deaf lawyer tried to ask the judge to repeat himself or slow down because he was talking too fast for the deaf lawyer to lip read, many judges who are trying to move cases along do not react well to such requests. Interpreting obviates these types of situations. Is it obviates? Sorry, I don't know that word. Interpreting obviates these types of situations? Yeah, my bad. Okay, then it says, although some extraordinary individuals succeeded in the legal profession prior to the ADA, it cannot be doubted that the ADA, coupled with technology, has enabled deaf persons to thrive in the legal profession for the past 20 years. As one deaf lawyer, who preferred not to be identified, wrote, "Most people prefer to do things exactly the same way they've been doing them in the past, an attitude which tends to harm disabled and/or deaf attorneys who can participate fully with some simple courtesy." The ADA goes a long way in changing such sentiments. I find that so true because, it's very hard to get access in a lot of places because they'll just be like, "No, I'm good," and literally the only fucking reason that they really have will be because fucking, they don't want to change the ways they've done things in the past. You know what I'm saying? So yeah. 2. Types of accommodations used. There may be something to the sentiment of ABC News journalist John Hockenberry, himself a paraplegic, opining that you realize the obstacles are just guys standing there telling you that it's impossible, and you know it's not. I'm sorry, I don't know how to say this word either. Is it opining or is it opining? My bad. Okay, then it says, but the hard truth is that without interpreting, it is extraordinarily difficult for deaf lawyers or deaf professionals in general to succeed. A. Minimal accommodations. Prior to the enactment of the ADA and the invention of sufficient technology, many deaf lawyers went through law school and practiced with very minimal accommodations. For example, a deaf student might resort to sitting in the front row while attempting to read the professor's lips or utilizing other students' class notes, either on a voluntary or paid basis. That's what they made me do. They would always make me sit at the front of the fucking class, and then whenever I still wouldn't know what the fuck is happening, I would be asking people, then I'd get in trouble for talking in class. So then they'd fucking move me. But I would talk to every fucking body. So no matter where they moved me, I'd still be talking in class. Fuck you bitches. Because I was one of those bitches that talked to almost fucking everybody. I didn't give a shit. You know what I'm saying? Now, I hate a good bit of those bitches because I understand their politics and their political beliefs, and I'm like, fuck all y'all with the ones that I don't agree with politically. But, when you're in middle school and high school, before you start paying attention to things, and then you start paying attention to things. Before you have those conversations, though, you'll go, I used to go talk to anybody. I didn't give a shit. But anyway, so I had no access. The only way like I was a passing student is because I loved to learn outside of school. You know what I'm saying? Um, so moving on. It says, did I read the parentheses that says either on a voluntary or paid basis about the class notes? I forgot. Okay, but it said, I hope that it is self-evident to the reader that for a deaf person to simply sit in the front of a class and attempt to read the professor's lips is of extremely limited utility from a learning standpoint. Ding, 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 ding. While some deaf persons are skilled lip readers, the task is still difficult even under the best of circumstances. Because so many words look alike on the lips, even the best lip readers can only capture 30 to 60% of what is being said by the speaker, and the rest of the spoken message is filled in through guesswork. Yes, I wrote an article about that called Filling in the Gaps. Then it says, this assessment of the utility of lip reading assumes optimal circumstances, such as the professor speaking fairly clearly and facing the deaf student directly. The deaf student is not tired or ill and has good vision. I do not have good vision. Additionally, discussion within the class must be non-existent. Yeah, like that ever happens? Given that many law school professors teach through the Socratic method, lip reading and note-taking, and is an especially poor way for a deaf person to learn much in law school. I learned the Socratic method in high school and middle school because we had to do the International Baccalaureate Organization program, and that teaches you through the Socratic method. I actually love this. What I like about the Socratic method is being able to do my own research. Like they would be giving us topics, we'd ask questions, and we'd go do our own research. And then we'd come back and he'd fact check our research, and then we'd take tests. And the test would be prompts, and then you could basically write whatever fuck you wanted, and as long as it was true, you got a point. And you know what I'm saying? And you just had to meet a word count. I actually really enjoy that grading because, like, I just felt like it was easier for me to get good grades. I don't know if I'm wrong for that, but that's how I felt. Okay, so then it says, although class notes provide some benefit, they do not come close to providing missing information lost during lip reading. Such notes are almost always taken by fellow students in the class, who may or may not substantially understand the professor's points. Moreover, even the most skilled note-taker can only write a handful of pages of notes from an hour-long class, when a word-to-word transcription of the same class would result in a 60 or 70-page document. Ooh, that's true. Then it says, some deaf lawyers utilize similar accommodations in court appearances. For example, Harold Diamond's practice required him to make several court appearances each week, and he was allowed to position himself in court where he wished so he could easily read lips. Sky Harrison employed a similar strategy as an assistant public defender in the Florida county courts early in his career, as did Charles Mack Gibson in his civil litigation practice in South Carolina. One 19th century deaf lawyer had his law partner write down important parts of court proceedings while they were trying cases. Richard Brown, who is now chief judge of the Wisconsin Court of Appeals, and this is, of course, time frame here, 2011, became deaf 5 years after he was elected to the bench. He recalls that he relied primarily on lip reading and residual hearing from his cochlear implant to follow courtroom proceedings in early years. For persons with mild or moderate, so by the way, in deaf community, we typically don't align with calling deafness a hearing impairment. That's typically a hearing assimilated term, and it derives from, they used to call us dumb. We told them stop calling us dumb. We're not dumb. We're just deaf. And instead of complying with our request to just acknowledge that we're only deaf, they started saying, fine, you're impaired. We are not fucking impaired, bitch. You're impaired. Anyway, sorry. So we're just deaf. That's a slur again. A lot of deaf people consider that a slur, consider that ableism, discrimination against us. By the way. So it says, I'm going to replace that with deafness. It says, for people with mild or moderate deafness, an assistive listening device such as an FM, or infrared auditory system was often sufficient. That's how my hearing aids work. They may have still needed note takers, and they have also faced the same difficulties as lip readers in terms of classroom discussion because only the voice of the speaker using the microphone, often the professor, is heard on the system. I have a Roger assistive mic, and it has a multi-directional mic, and I can listen from different directions for me. And then it says, nonetheless, such assistive listening devices are useless to people who have severe or profound hearing loss. For me, I have moderate to profound deafness, so because both of my ears have different deafness levels, you know what I'm saying? B. Sign language interpreters. For deaf persons who knew sign language interpreters proved to be an excellent accommodation. There are two forms of sign language that can be used by deaf law students and lawyers: American Sign Language, ASL, and Signed English. Oh, and also, just to put into context, this is in relation to quote-unquote United States of American history and law. Obviously, other quote-unquote countries under this colonial construct have different histories and languages in relation to that. And so then it says, for present purposes, it will suffice to say that the basic difference between ASL and English is that the former is a conceptual language. The literal translation for I have been to Chicago into ASL would be touch finish Chicago. The literal ASL translation for prosecutor could be any of blame person, government lawyer, complaining lawyer, other lawyer, or against lawyer. English, on the other hand, is a language that conveys meaning through specific word choice. Sign English is essentially a pidgin-like combination of both signs and English. That's not to be confused with pidgin signed English. So there's pidgin signed English, PSE, and then there's signed exact English. So there's ASL, PSE, and CSEE. American Sign Language has its own grammar, its own vocabulary, its own word order, its own word structure, and its own syntax. And by syntax, I mean you don't use a lot of the filler words you would use in English. In Pidgin Signed English, you use an English word order, but you still keep more of the ASL vocabulary and syntax. But then with signed exact English, that's signed exact English. You know what I'm saying? So, yeah. So it kind of sounds like right now they're talking a little bit more like pidgin signed English or contact sign in this description, in my opinion, than it would be signed exact English, in my opinion. But the rest of this says, not every English word is signed, but the literal translation of signed English is closer to English than ASL. And different signs will be used for the same English word when context so warrants. Id est. Satisfactory or sanction will be signed for the English word fine, depending on the context of the word's meaning. There is debate within the deaf community whether ASL is appropriate for sophisticated legal terminology for deaf lawyers or law students. Yeah, that comes from the deaf community who are assimilated into the hearing world, fighting deaf culture, in my opinion. Okay, but let's keep going. It says, some deaf students and lawyers have used ASL and believe it is sufficiently clear for legal work. Others disagree. noting that ASL is of limited utility for deaf lawyers and law students because ASL cannot pick up crucial nuances of certain legal terms. That's not true. Okay, that is, then just because you're not fluent enough in ASL to know that proper STEM terminology for it, or to come up with a new sign if you're not immersed in the deaf culture that way, because new signs are always evolving, in my opinion, doesn't mean that ASL isn't good enough for it. It just means that you aren't being a participant in its use in this way, in my opinion. And then it says, or because many legal terms simply do not have a corresponding sign language equivalent. I just addressed that shit. Then it says, several deaf law students have expressed frustration when interpreters were not familiar with terms used in the law context. I mean, a lot of interpreters, you would have to get interpreters specialized in the legal field to have an accurate interpretation when it comes to a lot of those terms, though, because it already takes interpreters like 20 years to become 80% fluent. So it would take them a long time. That is a thing. That would be a thing. Okay, so, and then it says, of course, sign language interpreters are only helpful if the deaf lawyer or student actually knows sign language. At least one law school was sued in part because it insisted on providing sign language interpreters as an accommodation for deaf students, when the student's knowledge of sign language was limited and other accommodations would have been more appropriate. Additionally, for deaf law students that utilize sign language interpreters, and oral interpreters for that matter, an accompanying note taker was essential. Whenever the deaf person turns her eyes away from the interpreter to write down or type notes, she inevitably misses what is being said at that moment. That is true. C. Oral interpreters. In the case of lip reading, an oral interpreter simply mouths the speaker's words without making any sound. The hearing, it should be deaf. The deaf person reads the lips of the interpreter, who is usually only 2 or 3 words behind the speaker. And for those not looking, they put hearing impaired, and I said it should be deaf. Anyway, it says the benefit oral interpreters have over lip reading is that they are directly facing the deaf person, whereas the actual speaker may be beyond the deaf person's sight lines. This helps to create an optimal lip reading situation. Oral interpreters gained popularity in the 1980s and early 1990s among deaf students and lawyers who did not know sign language. I think those are silly. I would rather just try and lip read a bitch speak and fuck it. And then it says certification for oral interpreting requires training and passage of an exam conducted by the Registry of Interpreters for the Deaf. You know what? I'm not trying to negate other people's support needs. That was probably a bad comment for me to make when I'm like over here like saying, you know, I don't know. Like, did I say it was silly or did I just think that? But anyway, I apologize. I'm probably being ableist against other deaf people's support needs. But I don't know. It just would be helpful for me. It's all me. Okay. And then it says, oral interpreters have been used often by lawyers in practice when the deaf lawyer had a family member or office assistant mouth the words for the deaf attorney to lip read. And then it says D, computer-assisted real-time interpreting. The final and most recent traditional form of accommodation for deaf lawyers and law students is computer-assisted real-time CART interpreting. And again, this was published originally, I think it was published in 2011. So at that point, VRIs weren't as popular or weren't like as big, you know. So now virtual relay interpretation is happening, but this is still, I think, very crucial for documentation purposes. You know what I'm saying? So, it says, CART interpreting is essentially captioning, similar to real-time captioning. Well, you know what? You know, maybe I'm wrong for saying that because, well, I mean, I just meant in terms of the most recent traditional form of accommodation. There's VRIs now, but CART is entirely different. A VRI, you're getting a virtual relay interpreter. A CART, you're getting the text. You know what I'm saying? So, it says CART interpreting is essentially captioning similar to real-time captioning used on live television broadcasts. such as newscasts, debates, or sporting events. A stenographer, or court reporter, or captioner stenotypes every word that is said in the room, and the translation is read by the deaf lawyer or student on a laptop computer screen. CART interpreting is not to be confused with simple typing. CART interpreting has effectively rendered oral interpreters obsolete, at least in formal settings. Lawyers and students who are not fluent in sign language have largely embraced CART interpreting and have sung its praises. Further, unlike other forms of interpreting, CART computers allow for the display of 24 lines or more of text, which allows the deaf person to take short mental breaks or take notes from the screen without missing information, which is nearly impossible with oral or sign interpreters. Given that demographics of deaf education have been favoring cochlear implants, mainstreaming, and lip reading over sign language for the past decade or so, with no change in sight. And I want to pause here and say that a lot of people who get cochlear implants, not all, I don't know the stats, but I have articles regarding this previously. Check my Jello program reporting for that, and you can check my article, my blog called People Who Hear But Don't Listen, from a person with a cochlear implant. I wear hearing aids. They have a CI. That article talks about how a lot of people with CIs are forced to get them. It's not like they choose to get them. So other people choose that for them. And for people who want CIs for themselves, go for you. You go test that out. It's people who force it I have an issue with. That's extremely harmful. Anyway, but yeah, I prefer to just raw dog it. I like being deaf. Fuck it. So it says, I predict that CART, or at least the next generation, voice-to-text technology, will become the prevalent choice of interpreting for future deaf law students or lawyers. And then it says 3. Experiences of deaf lawyers prior to the ADA's passage. In my research, I found several articles identifying an individual as the first deaf lawyer. These articles, however, were referencing individuals from the 20th century. While those lawyers indeed deserve recognition, the history of deaf lawyers in America goes back a bit further. A. The pioneers, late 19th and early 20th century. I kind of hate when people call the people who first started doing something a pioneer. It kind of, brings me back to colonialism, right? So are you saying, I don't know. Maybe we should stop that. Am I wrong for that? Like, I need to process this more, but I don't know. I don't know. But it says, anyway, it says the first deaf lawyer in the United States appears to be Joseph G. Parkinson. Mr. Parkinson became deaf at age 9 due to scarlet fever. He entered schools for the deaf, where he was put in advanced classes because, in his own words, he was deaf but not a deaf mute. He moved to Washington, D.C. to enroll in Gallaudet University, then known as the Columbia Institution for the Instruction of the Deaf and Dumb, and obtained a job at the Patent Office after graduation. And keep in mind that the terms deaf mute and deaf and dumb are also considered discrimination and offensive in deaf community and deaf culture as well. And then it says, Mr. Parkinson was described as a lad of uncommon cleverness and impressed his superiors at the Patent Office. He was the subject of a very interesting anecdote that exemplifies some of the attitudinal barriers encountered by deaf lawyers even today. As former U.S. Senator William M. Stewart of Nevada recounted to the Saturday Evening Post, reprinted in the Silent Worker, after his retirement from a long Senate career. While I was in the Senate, I paid several visits to the Deaf and Dumb Asylum, ableism, and found there a boy of great brightness. I secured for him a clerkship in the Patent Office. On a visit to Washington later, I went to the Patent Office to see the boy. I talked with the commissioner and learned that he was one of the most efficient clerks in the bureau and that he deserved promotion. I went to the Secretary of the Interior and asked for his advancement. While I was pleading his cause, Andrew Johnson was sitting behind me. I did not know he was there until he spoke up. He said, "Being deaf and dumb is no reason for promotion. God Almighty knows how to mark men." Yeah, ableist piece of shit, suck my dick. Fuck you. Anyway, it says, "I lost my temper and came very near to losing my senses. I sprang on Johnson. Get him! Intending to make an impression on his flesh. Yeah! If no impression could be made upon his sense of right and wrong, kick his ass! He jumped behind the secretary, and 4 or 5 clerks rushed up and got between us. That's disappointing. Why do we gotta do that? No, we're trying to have a Jerry Springer moment. And then he said he went out of the room with as little delay as possible. President Johnson's unenlightened outlook notwithstanding, Mr. Parkinson eventually earned promotions in the patent office and became licensed to practice law no later than 1883. He moved to Cincinnati and formed a law practice with his brother Robert H. Parkinson. Their practice proved quite successful. Both were counsel in several patent cases, including a few Supreme Court cases. And keep in mind, I think 1883 is whenever Alexander Graham Bell's memoir was first published. Time frame here. Historical context. So then it says, the brothers later opened up another office in Chicago, and Joseph Parkinson told the Washington Post in an 1891 interview that his income was way up in the thousands. As far as accommodations are concerned, Mr. Parkinson foreshadowed other deaf lawyers by having family members function as interpreters. Having not become deaf until age 9, Mr. Parkinson did retain some of his speech, which reportedly was not very difficult to follow. Nonetheless, according to one account, when Mr. Parkinson appeared in court and wished to make a point, he would write down his arguments on a piece of paper, and his law partner/brother would deliver the argument orally to the judge or jury. I presume that Robert Parkinson likewise wrote down important points in the court proceedings on paper for his brother to read. While Joseph Parkinson may be the most prominent of the pioneering deaf lawyers, he was hardly alone. According to the Columbus Dispatch, reprinted in the Silent Worker, a deaf lawyer named N. B. Lutz argued a case before the Ohio Supreme Court in 1893. Mr. Lutz, who lost his hearing after he had become a lawyer, took lip-reading lessons to communicate. Like Mr. Parkinson at the same time, and other decades later, Mr. Lutz utilized family members, his wife and daughters, as interpreters in the course of his business. He became so proficient in lip reading that with the aid of his wife, who listens to all that is said in court and repeats it to him, he has been able to keep up his practice. Having a family member willing to assist in the office was not a prerequisite for success for deaf lawyer pioneers. For example, Roger O'Kelly became deaf as a child and was practically mute as an adult, being able to speak only to utter brief exclamations. He communicated with the hearing world through writing notes on pads, and eventually earned a degree from Shaw University. In 1908, he was licensed by the North Carolina Supreme Court. In 1912, he earned a Bachelor of Laws degree from Yale University. He eventually returned to Raleigh, is it Raleigh or Raleigh? Shit, I don't know. Raleigh, North Carolina, and established a lucrative practice among the local African American community, performing legal services relating to domestic relations, real estate corporations, that's a comma there, real estate, corporations, and abstracts of title. And to keep that in context, he is black and deaf. And then it says, if succeeding as a lawyer while being deaf, actually, I think he's the first black deaf attorney. Um, I did a live, another video. I think it mentions him. It linked in the description of this. Hmm. Well, unfortunately for me, OBS disconnected and then reconnected. And so I don't know at what point it stopped. So I apologize, but I'm just gonna repeat what the fuck I just said, but I'm not gonna reread all of it. I'm just gonna summarize this in my own words. So what we had just talked about was how Roger O'Kelly was the first black, deaf, blind attorney that I can know of, that I know of, and fucking he he got a Bachelor of Law degree from Yale University after earning a degree from Shaw University. He was licensed by the North Carolina Supreme Court, um, and we went to Raleigh, North Carolina, and had a lucrative practice there among the black community, African American community there. And if succeeding as a lawyer, and then it keeps going and it talks about how he became blind in one eye from a football injury. And that's the point where OBS told me it disconnected and reconnected. So I don't know, like, if that caused a delay for you, if you, I don't know, sorry. But anyway, so we're just going to keep going now. It said, interestingly, it was the eye injury, not his deafness, that worried Mr. O'Kelly's friends that he would not be able to practice law. O'Kelly remarked that he had one good eye left and would make it anyhow. He apparently did. Another pioneering deaf lawyer was Theodore Grady, who became deaf as a young child and learned sign language at a school for the deaf in Berkeley, California. He later enrolled at the University of California and did remarkably well at a mainstream school, even by today's standards, let alone in that era, being elected to student government and being involved in many extracurricular activities, including the Glee Club. Upon graduating, he was elected Deputy City and County Tax Collector for San Francisco and held that office for several years. Eventually, Mr. Grady found himself drawn to the study of law, reasoning that the chances of an intelligent deaf man in the practice of law were about as good as any enjoyed by more fortunate hearing men. In 1895, he joined the law office of Garber, Bolt, Bishop, and Wheeler as a law clerk. 2 years later, he applied for admission to the California bar and appears to have set precedent for being the first deaf person to request an accommodation for a bar exam. Yeah, at the time, the custom was to give the examination questions orally. Mr. Grady requested that the questions be given in written format. His request was granted, and he passed the examination. I could not find anything regarding the substantive law that Mr. Grady practiced, but he was an active practitioner. At least one clue about his responsibility comes from Gilbert C. Braddock, who reports that Grady submitted a paper on deaf lawyers to the Paris International Congress of Deaf in 1900 and highlighted that office work is far the most important branch of law practice. Litigation does not always occupy the greater portion of a lawyer's time. Many of our successful practitioners never go into the courts at all. Given Grady's assertion, which was undoubtedly as true then as it is today, in the 1900 paper, and given that I could not locate a reported decision in which he made an appearance, it is most likely that he primarily, if not exclusively, performed legal preparation at his firm's office. Okay, I feel like that's a reasonable conclusion, or assumption, rather. Mr. Grady claimed one advantage to his deafness over his hearing colleagues. By communicating with the firm's clients by passing notes, he could get at the gist of the matter sooner by writing than by speech. Clients will tell the truth if a statement is in black and white, but not always otherwise. Is that true? And then it says, other deaf lawyers of that era followed similar paths as Mr. Grady. For example, Paul Cone became deaf during childhood, but continued in regular schools and did not learn sign language, even though he was not a proficient lip reader. He eventually, well, lip reading wouldn't matter in relation to that, because what? It's not like it's not fluent anyway. It says he eventually was admitted to practice law, but did not try any cases. Rather, he joined an Albia, New York, I don't know how to say this, Albia, New York law office and did much office work and proved himself skillful in arguments and clinching facts. Similarly, William Egan was a deaf-mute ableist who was admitted to the practice of law and joined a law firm that specialized in prosecuting patents, pensions, land, and war claims against the government. Yet quite a few deaf lawyers of that era maintained practices that included appearances before tribunals. A deaf lawyer identified as B.F. Brown graduated from Gallaudet and reportedly had been successful in prosecuting many pension claims for old soldiers. Alva Jeffords was a deaf-mute who specialized in probate law in Missouri. His probate practice was apparently successful enough to keep him constantly busy, as he often traveled away on cases for weeks at a time. Moreover, foreshadowing many deaf lawyers in the 20th century, Mr. Jeffords was widely sought after for legal services by other deaf people because he could communicate with them. And then there are people such as Henry White, a deaf-mute admitted to practice law in Arizona, but never actually did practice. Instead, Mr. White taught deaf children and wrote a book entitled Law Points for Everybody that reportedly sold more than 60,000 copies in New England alone. The above discussion is not intended to be an exhaustive list of early deaf lawyers. I found other instances of deaf lawyers being identified. Unfortunately, not much was said about them, so I cannot comment on anything beyond their existence. And it's B, the pre-ADA modern era. So now we're getting into, so we begin with some of the beginning shit, like what are the beginning of documentation regarding deaf people in the legal profession, right? And so now we are going into modern times, but still before the ADA. And by modern times, I just mean within the last 100 years. I don't really know, would you say that's still modern? Who knows? But in terms of era, I guess. Okay, so, and then it says the 1930s to 1970, the Dark Ages. While affording the greatest respect to these pioneers. Oh, did I mention that it said one on that? Okay, my bad. And then it said, while affording the greatest respect to these pioneers, any beachhead they established as trailblazers for future deaf attorneys was largely lost by the 1930s. I was not able to account for the existence of any deaf lawyers in the United States after Mr. O'Kelly in 1927, who was probably near retirement age by then, until Harold Diamond and Lowell Myers in the mid-1950s. And even Mr. Diamond and Mr. Myers appear to be the only practicing deaf attorneys until the 1970s. So that's what we call this, the Dark Ages. Then it says, A, theories for the dearth. So I have several theories for the dearth of deaf attorneys in this period. Am I saying this word right? I don't know. Then it says, first, the nature of the legal profession changed drastically in the early 20th century. Although many law schools existed in the latter 19th century, a formal law degree was not a requisite for obtaining a law license in that era. An aspiring lawyer could perform an apprenticeship under the tutelage of an experienced lawyer, and then take a bar examination for a license. This appears to be the path that most, if not all, of the deaf lawyer pioneers undertook. One-on-one instruction with a master was a far more conductive learning experience. Is it conducive or conductive? Conductive learning environment for deaf students than a classroom with hearing peers. By the early 20th century, however, the American Bar Association and American Association of Law Schools had wielded their influence to establish minimum standards for obtaining a law license nationwide, including completion of a 3-year graduate program. Oh, hi Crunchy Cheesy Wasp Rasp. Hope you're having a great day. We are just talking about deaf legal representation. And right now we're talking about theories about why the dark legal ages existed for deaf people between 1930s and 70s. So yeah, it says, did I read the line that says most jurisdictions eventually adopted such requirements for licensure? That was a line. Anyway, after that it says, whatever benefits these changes brought to the legal profession and society in general, it is hard to view them as anything other than detrimental for aspiring lawyers. For one thing, there was nothing to prevent an unenlightened law school admissions committee from summarily rejecting any deaf person seeking admission to law school. As late as 1968, deans at Brooklyn Law School advised student Michael Chadoff to drop out and find another profession when he became deaf following surgery to correct a neurological condition. Moreover, disability advocates suspected that law schools were requiring applicants with disabilities to provide higher board scores and grades than non-disabled peers to prove their worthiness of admission. Isn't that fucked up? I wonder where we've seen this before. Intersectionality. Even if a deaf applicant had been admitted to a law school, there was no obligation on the part of the school to provide any accommodations. Surely the prospect of paying for not only tuition, board, and books, but also for interpreters, a considerable expense, discouraged deaf students from considering law school. And even if the deaf student could pay for interpreting out of his or her own pocket, as some did in the 1970s, interpreting for the deaf did not materialize as a formal profession until the mid to late 1960s. And you can check my deaf history lesson playlist for information on the timeline of the historical context of all of that. But around the 1960s is when sign language actually even first became recognized as a language. So under colonialism in the United States, after being banned at the Milan Conference of 1880. Anyway, moving on. It said, furthermore, many prospective deaf students were undoubtedly discouraged from entering the legal profession, as well as many other professions, because the communication methods for conducting business and being informed of general matters were becoming increasingly inaccessible. The telephone was the most obvious example of technology that provided great benefits for society in general, but had a devastating impact on the employment prospects for deaf persons. You know what? Isn't that ironic? Damn. I need to marinate on this one. I'm going to have to reflect on this and come back to this concept. This might go in my AGB lives. It said, it is one of history's great ironies that Alexander Graham Bell, who had a deaf mother, a deaf wife, and spent much of his career as a teacher for the deaf, invented the machine that cut deaf people off more from the world, depriving them not only of communication, but of jobs and a full place in the hearing community. That was really true between when the phone came out until video phones, but since video phones and up until 2011, I feel like video phone technology wasn't where it's at now to where you could truly say it gave that access. But like today, we have more access because of phones. But yeah, there was a time period where we did not, and we still don't through like that portion. But anyway, and we still don't when it comes to like needing to make doctor's appointments and shit like that. You know what I mean? We only do like with each other. You know what I mean? Okay, but it says, whereas lawyers in the late 19th century conducted business by face-to-face meetings, U.S. mail and telegraph, businesses in the early 20th century had increasingly employed telephonic communication. And then it said, I would be remiss if I did not acknowledge another theory as to why there are no deaf lawyers during the era. Historically, the two most popular methods of educating deaf children were oralism, i.e. speaking and lip reading, and sign language. The former was championed by, among others, Alexander Graham Bell, and the latter was championed by, again, among others, Edward Minor Gallaudet, the first president of what is now Gallaudet University. In 1880, the International Congress of Educators of the Deaf decreed that oralism, rather than sign language, should be adopted as the accepted teaching method for deaf children. Henceforth, through approximately the 1960s, schools for the deaf nationwide shunned sign language and favored oralism. Oralism fit within the conformist spirit of the era. However, it was an exceptionally difficult skill to master, especially for children who were born deaf or became deaf before they learned how to speak. And I want to put out there that there's been headway in improving deaf access through sign language recently, but there's still, in some ways, but still in a lot of ways, we're still not having full access with accommodations when it comes to institutions. Okay. Like my schooling was bullshit. Anyway, it it says many simply could not do it, even though the skills of speaking and lip reading bore no correlation to intelligence. The result was that, despite some success stories, many deaf children in the late 19th and the first half of the 20th centuries grew up with undeveloped or underdeveloped language skills. This correlates in regards to a whole nother discussion about language deprivation and language disfluency. Okay, but it says if sign language had been more accepted among deaf educators throughout the 20th century, might there have been more deaf lawyers during that time? I do not believe so. Counterfactual history is inherently uncertain, but such individuals surely would have run into the same obstacles described earlier in this section. So, for me, if sign language was more accepted throughout the 20th century, there would have had to have been, the accommodations in place legally to have access for that to then impact there being more deaf lawyers, in my opinion. But anyway, it says, if anything, a signing deaf applicant who did not speak would have encountered even more skepticism and difficulties at law schools during this period. And if you understand how hearing people talk about deaf people, you can read that about that in my AGB memoir reading. Particularly at that time, you'll understand more about what is meant by this. So then it says, finally, there is the problem of low expectations. It was hard to shake attitudinal barriers that deaf persons could not become lawyers. Yeah, I still have hearing people try to tell me that I can't do music as a deaf person, like suck my dick. And then it says, for example, Janine Kramer, Madeira, remembers that adults patronized her in grade school, it is the 1980s, when she professed her desire for a legal career. They kind of laughed and patted me on the head. Miss Madeira graduated from Bolt and spent several years at the Los Angeles office of, is that Latham and Watkins, before joining the LA County District Attorney's Office. But she was hardly alone in encountering skepticism about entering the legal profession. On the flip side, a self-perpetuating cycle of defeatism existed within the deaf community. As Judge Brown explained, deaf people have felt for so many years that because the doors to the legal profession were closed to them, why should they bother going into the law? It was difficult to shake such perspectives as long as few deaf people were willing to break them. I feel like that's victim blaming for hearing people not giving us access, as if we aren't trying and haven't been trying. I don't believe that I believe that every human being goes through self-perpetuating cycles of defeatism, but I don't believe that putting that type of label on the deaf community is accurate. In fact, I would call that a stereotype and ableism and discrimination and harmful, because it victim blames us for how hearing people harm us, in my opinion. But anyway, and then it says B, Harold Diamond and Lowell Myers. I had long believed that the first deaf attorney in the modern era was Lowell Myers. However, in the course of researching this article, I now believe that the title should go to Harold Diamond, who became a lawyer in 1955, 1 year before Myers. Mr. Diamond became deaf at age 14 due to a near-fatal auto accident. Contrary to advice from doctors that he transfer to a residential school for the deaf, he remained in normal schools, keeping his deafness a secret. And I did in my 7.5 hour long live stream about deaf identity, I mentioned there are many reasons that deaf people don't discuss that we're deaf to people, and that's what that reminded me of. Anyway, it says, like Theodore Grady, he did remarkably well in a mainstream school considering the era, becoming high school class president and valedictorian before earning a scholarship to University of Pennsylvania. After teaching accounting for a few years, he returned to Penn to earn a law degree. He worked for the Securities and Exchange Commission in a large Philadelphia law firm before forming his own general practice firm. His accommodations in court, at least through the 1980s, were minimal, consisting solely of asking for special seating so he could lip read. Like many other deaf lawyers, he used his secretary as an oral interpreter for telephone calls. Hearing aids were helpful for him to discern sounds, but not nearly good enough to understand sounds such as speech. He credited his success in trial partially to his deafness. He believes that the ability to move around more freely in court to position himself for lip reading earns him extra attention from the jury. He also says that because he is deaf, he puts far more emphasis into trial preparation than his adversaries, and can quote testimony fully and accurately from memory in a manner that unnerves witnesses and win cases. So I worked for an attorney, and he gave me a list of a bunch of things for me to do, and I came back with a list of 25 questions about his agenda. And whenever I was telling my 70-year-old client about this, he told me that I probably intimidated him by doing that and shouldn't have done that. Um, and so, but I had questions. He gave me all this shit to do. I wanted to know. Um, and so I was also like, in one meeting, I was like telling him, I was like, on this day, at this time, you told me you wanted me to do something. Do you still want me to do that or not? You know what I'm saying? I'll be that fucking way when it comes to like getting work done. Um, and sometimes my clients love that about me, and sometimes they're like, bitch, fuck off, all right? Like, I'm trying to hit my fucking weed. I don't need you in my head. Um, you know what I'm saying? Nobody smokes weed around me. No, I didn't say that. Marijuana is legal in certain states, and I work with clients remotely. So if it's legal in their state, it's legal in their state, and that's all I'm gonna say. You know what I'm saying? Anyway, we're gonna keep going. It says, like many other deaf lawyers, Mr. Diamond encountered skeptics. You know what? Okay, back again. Sorry. I had some mixed reactions about earning extra attention from the jury. On one hand, I feel like um, hearing. So like when hearing people um think that deaf people just functioning is this amazing feat. It's called quote unquote inspiration porn. And so I feel like he's kind of weaponizing that through the jury. So on one level, I'm like, maybe that's harmful by perpetuating it. But on another level, I'm like, you know what? People are ableist. Fuck it. You know what I'm saying? I don't know if that makes sense. All right. But then it says, like many other deaf lawyers, Mr. Diamond encountered skeptics. He recalls a criminal case when a trial judge questioned whether a deaf lawyer could be competent to carry on a trial. Diamond recalls what transpired next. I told the judge, let's go through the case, and if you think I'm not competent, I'll never try another one. We went through the trial, and when we got to the summation, the DA summed up for an hour. I talked for 20 minutes. While the jury was out, the judge called counsel to the bench. He was really angry. He told the DA, if you knew the case as well as Mr. Diamond, you could have summed up in 20 minutes too. Yeah. Okay. You know, that's where he and I differ. I can't sum shit up in 20 minutes. I will talk forever. Well, I can sum up in 20 minutes, but people usually don't like it when what I have to say in 1 minute. They're like, you're being a bitch. You're over exaggerating. Anyway, I'm sorry. Fucking, but people will be like, all right, I'm sorry. It says Lowell's hearing began to deteriorate when he was a teenager, and he was deaf by the time he was an adult. He became a CPA and tax investigator for the state of Illinois and took night classes at John Marshall Law School. He graduated second in his law school class in 1956 and became a tax attorney for Sears, Roebuck and Company. Earning an impressive salary of $92,000 in the 1970s from his corporate job, he was able to set up a side practice servicing deaf clients. Like Mr. Diamond, Mr. Myers prided himself on extensive pretrial preparation, and like Mr. Lutz before him, Mr. Myers used family members, usually his sister, as oral interpreters for telephone calls and court business. My bad, I'm making that plural. And like Alva Jeffords before him, many deaf individuals throughout the state sought out his legal services because no one else could communicate with them. Yeah. However, for all his advocacy on behalf of the deaf community, which was indeed extensive by any measure, Myers' legacy is somewhat complicated by the fact he discouraged other aspiring deaf students to become lawyers. Oh shit! Professor Tucker recounts when she was considering applying to law schools in the mid-1970s. Could a deaf person make it through law school? Apprehensively, I pinned a letter to the only deaf lawyer I had heard of, a man who had become deaf as an adult and practiced law for a corporation in Chicago. I knew of this lawyer because he had represented a deaf man in a well-known case that was reported in a book and movie called Dummy. Damn, the ableism. It said, "What do you think?" I asked him. "Should I go to law school?" No. His response was emphatic. "It's near impossible to get in. And if you do get in, being deaf, you'll never make it through," he wrote. "And if by some luck you squeak through," he continued, "you'll never get a job. No one will hire a deaf lawyer." That was all it took to make me determined to apply to law school. Make me determined to apply to law school. Good. I think in this case, he might have wanted her to go, but was trying to discourage her, to not discourage her to go on a whim, but to go if she really wanted to, making her known of the obstacles she will face in this case. But maybe that wasn't what it was. It could have also been he was being a fucking dick and discouraging people, or it could have been like he was jaded and of the own shit he went through and was like, it's not even fucking worth it. Or it could be, what they were discussing before, like the deaf community thing. You know what I'm saying? But I feel like it's crab bucket theory for sure. You know what I mean? Okay. And so then it says Myers passed away in 2006. And as far as I know, never expressed regret for discouraging deaf persons from entering the legal profession. Linda Myers, Lowell's daughter, theorizes that her father was an extraordinarily brilliant man, a member of Mensa, who succeeded in an era with minimal accommodations and genuinely thought that becoming a lawyer was too difficult for other deaf persons. Oh, maybe he had to stick up his ass and thought he was better than others. Well, fuck him then. Anyway, it says, however, she also stated that her father spoke at numerous deaf gatherings and with individuals about his experience through the early 1980s and onward, and inspired several deaf individuals to apply to law school. I don't know. Maybe she's covering his ass. I don't know. Because the AGB Legacy Foundation doesn't really like to talk about the shit that AGB did. So, all right. I think what we're gonna do is end the reading here, and what we'll do is fucking pick up next time on page 28. Next time we're gonna pick up on where it begins speaking on the Rehabilitation Act of 1973. But for now, let me summarize what we've read so far before I summarize the live stream. So far we have, when it comes to reading breaking the sound barriers, what we read was, just the introduction in terms of deaf identity issues, as well as like how before the ADA, there was a lot of obstacles deaf had to go through regarding legal access. And so we discussed the need for proper accommodations for deaf lawyers. We discussed types of accommodations used. Um, then we've discussed such as sign language interpreters, oral interpreters, writing, CART, and I orally discussed VRI for a second there. We've discussed experiences of deaf lawyers prior to the ADA's passage, which is, we're still in that section. We're still prior in terms of this reading. We discussed what they called the pioneers. I don't like that term, but just reading what it says, but from the late 19th and early 20th century, in terms of some of the first documented deaf attorneys under colonial United States. You know what I'm saying? And then we discussed the pre-modern ADA era, from the 1930s to the 1970s, we had the Dark Ages. There was only 2 documented attorneys that were found during that time. We discussed some theories for that. And then we left off discussing Harold Diamond and Lowell Myers, who are 2 of the first attorneys coming out of the dark legal ages, um, that are documented for things that they did. There were other deaf people, but there's not much to say about a lot of the deaf lawyers that didn't have much documentation available on them. So, those are just 2 figures that in that process, you know what I'm saying? In the modern era, 2 of the first deaf attorneys. Um, and yeah, and so that's where we left off. Next time, we're going to pick up at the Rehabilitation Act of 1973. And I'm going to, in that live stream, I will link some research that I did on that there. I might go ahead and link that here too. So, yeah. And then that's where we're at. Our next live stream regarding Deaf Awareness Month, we will be continuing part 2 of finishing Breaking the Sound Barriers by Don F. Stanton, reading reaction commentary on that guy. And so that was really our topic for today. In conclusion, we talked about we primarily did our reading of John F. Stanton's article called Breaking the Sound Barriers. And it is about how the American with Disabilities Act and technology have enabled deaf lawyers to succeed. And we talked a little bit about who he was. We went over that SCOTUS blog article that's linked in the description of this video. He was a deaf appellate lawyer with the U.S. Department of Justice in 2016. I am typing that out there. And he's known in the deaf community for swearing members of the Deaf and Hard of Hearing Bar Association into the Supreme Court bar. So, yeah. And I highly recommend you check that out. And if you're interested about the concept of what the sound barrier is as well, from where that name could come from, I linked that description in the video too. So thank you for joining me today. I hope to see you for part 2. I appreciate you. Thanks for joining me this Deaf Awareness Month. It means a lot to me. So yeah, and in part 2, I am going to try to better process and reflect and conclude on the entire article as a whole and its importance in relation to Deaf Awareness Month. Before we close out though, I do just feel I should say, again, the reason it is, in my opinion, so important to consider these concepts, theories, and history behind what gives deaf people access is so that we know how to better advocate for ourselves and reflect on deaf autonomy. So yeah, thank you for your time today. I hope you have a great night, and yeah, take care of yourself, and bye. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty and check in during live streams to get points for rewards.